All right, welcome to my channel again, lovely humans. Here's some Karen Reed updates. I'm having a real chill, cozy Sunday over here, so I was able to do some upkeep and research for the Karen Reed trial. I'm gonna insert myself here. I am not a legal expert in any way, shape, or form. I have never been paid to do legal duties. That is not where my studies were. I did a short section when I was in college of criminal psychology, which really doesn't apply here. But I just want to be transparent with all of you that I am not a lawyer or paralegal or anything. I am just a law enthusiast who is sharing with you some updates and things that you can find with publicly accessible information that I will link below for all of my sources. I'm just an enthusiast sharing my enthusiasm with whom I hope are other law enthusiasts. Okay, back to what we're doing. And we have it. There's been so much happening in the last few weeks, and the Karen Reed retrial is currently scheduled to start in April with jury selection on April 1st. So we're a little less than a month away from that potentially happening, but there has been a lot going on in between, including some stuff that would cause a dismissal if it comes true. We'll touch on that in just a couple minutes. We're gonna get started. Just a little recap, Karen Reed has been charged with backing into and causing her boyfriend, Officer John O'Keefe, to go unconscious and then leaving him in the snow where he died of hypothermia throughout the night in January of 22. So Karen Reed had an original trial last year in the summer of 2024 that ended in a hung jury and a mistrial due to the hung jury. And despite the defense's best efforts, they were not able to get any of the charges dismissed, particularly counts 1 and 3, which they said the jury had made verdicts on. They just didn't understand that they could put those on the paper if they hadn't come to a conclusion on all of the charges unanimously. But that didn't fall through. The Massachusetts Supreme Court ruled in favor of the Commonwealth. That is what Massachusetts calls the prosecution, and said that they didn't write down a verdict, so there's nothing that can be done at this point. If it's not written down, then that's it. Even bringing the jury in now for a poll wouldn't change anything that they didn't write it down, and that's just the way it is and what happened. It is also worth noting that polling the jury is not a common practice in Massachusetts courts. So even though that would have solved a lot of problems, it was just not something that commonly occurs there. So I was very upset before about Judge Canone doing that, but upon further investigation, it's like, oh, she's not trying to be one way or the other. She's just following Massachusetts standards. So we have that going on. I have my notes right here before me. There's a ton of them going on, a ton of litigation happening. And one of the things that has happened is arguments of experts. So Special Prosecutor Brennan has been brought onto the court, and his main aim the last month or so has really been to try to get rid of experts on the defense's behalf. He started with a medical expert who is an expert in identifying dog wounds, because there were the only injuries that were on John O'Keefe were blunt force trauma to the back of the head, and inside his inner arm was a series of weird looking wounds that it has been repeatedly pointed to be dog bite wounds. And this is important because where John O'Keefe was found, for those of you who don't know, he was found in the yard of another police officer, Officer Brian Alberts, and the Alberts had a German Shepherd named Chloe, who had been known to be aggressive with strangers and other animals. So that was important. He had no other injuries, any other contusions, bruising, or anything else on his body, despite the Commonwealth's theory being John O'Keefe, I almost said 4 different names there, pulled up in front of the Alberts with the intention to go to an after party, since the whole group of them, Alberts, McCabe's, Karen Reed, John O'Keefe, and some other people, were at some bars right before, and then they were going to continue their partying at the Alberts house. The Alberts and the McCabe's and other witnesses there claimed that John O'Keefe never made it into the house. They didn't even know he had arrived there, even though his body was found in the Alberts' yard. He was found in the middle of the yard, away from the curb, and the Commonwealth says that Karen Read hit him, backed into him, hitting him in the head, sending him flying into the middle of the yard, hence rendering him unconscious. And then he was unconscious in the snow in Massachusetts in January, and he died ultimately of hypothermia. They claimed that she had a cracked tail light, and that is what caused the injuries on his arm. One of the experts that the defense has, that was brought in the first trial that the Commonwealth wants excluded in this new trial, is the ARCA experts. The ARCA experts are a group of biomedical engineers who are able to do reconstruction stuff. They were originally hired and brought in not by the defense or Commonwealth, but by the federal investigation brought about by this case because of the heavy involvement of the police. And the defense is saying that everyone involved is doing a cover-up, framing Karen Read for something that happened inside the Alberts' house. Hence all of this craziness happening. And so the ARCA experts, if you have watched Emily D. Baker, her chat and things, will refer to them as the crash daddies. They created a special cannon to try to recreate a glass getting thrown and breaking the taillight in the way that it was shown on Karen Read's Lexus, which is, of course, the attempted murder weapon in this case. They were unable to reconstruct it in the way that her taillight had been broken, and the taillight being broken had been explained by a ring video at John O'Keefe's residence, where you can see Karen Read backing into and hitting a vehicle in John O'Keefe's driveway with that same taillight. That is where the taillight had gotten broken, not from hitting John O'Keefe later on or from throwing a glass during a fight that same night, as the Commonwealth claims. The reconstructionists from ARCA also were of the opinion that no matter what they did, they could not create an incident where the same or similar injuries happened in the way the Commonwealth's theory would present. They were like, we could not back a vehicle. They used a similar black Lexus. They could not back a vehicle to be able to move an adult male from the curb to the middle of a yard without additional injuries, and trying to back into a person with the back of their head only and somehow their inner arm getting cut on a broken taillight. They said they just could not reconstruct that scene to make it anywhere plausible and feasible. So obviously the Commonwealth doesn't want their opinions being presented to the jury again. And the ARCA experts had already been voir dired and limited in their explanation of what they were allowed to give, because even though they are biomedical engineers who are able to make injury assessments, Judge Cannone was very firm in saying that you are not medical doctors. You do not have medical doctorates. You are not allowed to make opinions about medical injuries. So they weren't allowed to give opinions on how or if the injuries were obtained or occurred on John O'Keefe. They were only allowed to say that in their reconstructionist and, going through all the technical things of what they did to reconstruct various parts of the scene, they were unable to make it happen in the way that fit the Commonwealth's theory. And Brennan said that they were lied to because they didn't have evidence turned over by the defense, as in there was conversation and payments made to ARCA's experts, and that was not turned over, in any conversations and correspondence between the defense team and ARCA was not turned over to the Commonwealth, and therefore that is a violation of not turning over evidence, and that the defense straight up lied to the previous jury, saying that they did not pay the ARCA experts when the ARCA experts were in fact paid by the defense team. Well, Judge Cannone got really mad when she found out that he misrepresented that Brennan misrepresented correspondence himself, and that the correspondence things had been turned over by the defense. And the defense, particularly Alessi, had said that they didn't have any outside correspondence or communication with the ARCA experts outside of, are you available to come to trial? Here's when you need to be there. That they did not have any kind of depositions, they did not have any interviews, they did not talk to them outside of that. And that at the time of trial during the summer of 24, they did not pay, or have an account or contract with ARCA in any way, shape, or form. The payments that they did end up making to ARCA, A, were turned over, and B, they said that that wasn't until well after the trial was done, and they were hit with what the defense called an out-of-the-blue bill that they were not expecting to cover the ARCA experts' expenses, hotel stays, food, and their time for being at trial. They said that they were fully under the understanding that the ARCA experts were coming of their own will and volition on behalf of the federal investigation to tell the truth and their opinions in the non-federal investigation, and that when they were hit with the bill, it was a surprise to them and that they had turned that over at the time. The defense also hits back with some stuff about our ARCA experts because they also are trying to exclude an expert from the Commonwealth's team. The defense saying, based on your Honor's ruling in the previous things, that ARCA, who are biomedical engineers, were not allowed to make opinions about the injuries to John O'Keefe's bodies. Their expert is not a medical doctor, therefore his opinions on the injuries should be excluded, and since that's the only reason this expert is there, that expert should be excluded entirely. There's also argument over the incoming of 3D scans that are supposed to replicate Karen Read's taillight and how she acquired them. There are 3 running theories on how Karen Read's taillight got broken. Sorry, I couldn't think of the word, it was right there. The Commonwealth says, according to their thing, she backed into him, hitting him with her taillight. That's how it got broken. The Commonwealth is also trying to make an argument that the two of them, the reason why she hit him is that in her intoxicated state, both of them were drunk at a bar, and she threw a glass in anger at a fight they were having that broke the taillight, and so the taillight being broken is what caused the injury to John O'Keefe's arm. The defense says that it got hit when she backed out of the car, as we mentioned before. So there's some arguments about the entrance of 3D scans and models coming in to determine those scenarios. The other motions that happened before last Tuesday were also things about Karen Read's interviews that she did with NBC and Boston Magazine with Gretchen Voss, where the Commonwealth demands all uncut raw footage and interview materials that were used because everything you say can and will be used against you in court. So they wanted everything that was said edited. They want all of that footage so that they can comb through it and be able to use it against her in court. But the other thing that might be causing this trial to get dismissed is a Brady violation. Brady violations are Brady versus Maryland, where it has been determined that all evidence that one side has to be turned over pre-trial to the other side, especially exculpatory evidence. Exculpatory being evidence that would show the defendant could not do what they have been charged with doing. And the Brady violation in this case, the defense claims, is how they want to know where all the Sallyport video is and where it's coming from. And the Sallyport is the Canton, Massachusetts Police Department garage where Karen Read's Lexus was being held and where they put vehicles and other things that are gathered from investigations for storage. There is 24/7 video surveillance in the Sallyport and outside of it. However, all of the evidence on the day before, and day after, and times with the Lexus and the Sally Port were not turned over to the defense. They were supposed to all be turned over by October 2023, which is when the court had put in an order to do that. It's like, yeah, you need to turn all this video stuff over to each other, etc. They also are claiming, they being the defense, is claiming a rule violation of 14 for specifically the state of Massachusetts about not turning over all evidence in a timely fashion on top of the Brady violations. They are claiming that they were getting video right before the trial, in the middle of trial. And if you remember, if you don't, if you weren't here for it, in the last trial, the Sally Port video had been inverted and there were pieces missing, specifically pieces of where Karen's taillight was being examined. And the defense is saying that this is convenient for the Commonwealth in a suspicious way. The Commonwealth is saying, when we got the video, specifically Special Prosecutor Brennan, who was brought on to the second trial specifically, he's like, I'm giving you stuff as I find it. And yeah, there is some stuff that should have been turned over, but we only have bits and pieces. We do not have the full total data from the original Sally Port recordings, as those have a limited data thing of about 30 days. So 30 days from January 2022 into February of 2025, what are we supposed to do about that? But the defense is saying, oh, no. You sent us video after the trial, months after the trial. They're getting random clips and video bits here and there, including recently being given a piece of particularly suspicious evidence involving witness Brian Higgins, who is one of the people the defense says that the police department was trying to cover up for. Brian Higgins is another police officer / detective who worked with Canton PD, and he was also in kind of an on and off flirty thing with Karen Reed, and that he had claimed on his phone records that he never talked to anyone that night after he left the Albert's residence, that he never saw John O'Keefe after they left the bar, and that if there's anything that says that he called one of the Alberts, which there was a call to Brian Albert, very late in the night, early in the morning, he said, no, that was a butt dial. I never talked to anyone. But the new video clip that the defense received shows at that time Brian Higgins at the Sally Port on the phone talking. So that means that his butt dial was just butt memory, quite frankly, at least according to the defense. They didn't use those words exactly. I'm paraphrasing. And there's other things too, including when officers were standing around looking at it, because the defense also claims that suspiciously, months after the incident happened, suddenly the Canton police were able to find pieces of taillight months after the event happened around the Alberts residence. And so they're like, there's video that is missing, and the video that has been turned over shows a lot of the officers around the taillight, and they suspect that the additional damage to the taillight was done by the police officers. That video footage was intentionally cut out and missing, and then that's how they were able to find all of these pieces well after the event happened. There's also a witness that the prosecution tried to get excluded, who was a neutral third-party towman who reported what he saw on Karen Reed's vehicle the morning of John O'Keefe's body being found. There's also some unturned over footage showing Jen McCabe, one of the most controversial witnesses in the case, shortly after the body was found, going into the Alberts residence and then coming back out. So all of this video evidence is not going well, and the defense is claiming Brady violations, and Brady violations means dismissal with prejudice, which means the case is getting thrown out and it can't be brought back. That is what they're going for. There's been a lot of back and forth between violations of not turning over evidence between the Commonwealth and the defense since then. And this last bit is a small kind of, compared to everything else, tiny tidbit. The defense team wants to add another lawyer who just needs an affidavit sent in. If you don't know what an affidavit is, it's basically a document that has been signed by a notary or other outside person, such as an oath commissioner, to be able to say, yes, these statements that this person says are true and valid when they were made outside of the court, to allow for things. That's pretty common. It happens all the time. We want somebody new. We have somebody coming into our team, blah, blah, blah. Here's their information. And yeah, so we are currently waiting on the Commonwealth's response to the Brady violations for dismissal. And that's pretty much what the defense has been really aiming for. I think they have a really strong case going into April. The judge already issued a continuance, something that she did not allow in the first trial, even though both sides had asked for continuance. She allowed a continuance from January to April. I do not think she's going to allow one again. So in the next week or so, we should be getting the Commonwealth's response to the Brady violations, which I think are going to be some of the same things that we've been hearing from Special Prosecutor Brennan. Just, we're getting evidence as we're getting it in. We don't know where it's coming from. No one else knows where it's coming from. It was found on a random computer drive by some former detective randomly. And as we're finding stuff, we're turning it over. There is no violation, at least on their current part here. He can't speak for the former prosecutor, Lally, who was the lead prosecutor in the original Karen Read trial. So those are the Karen Read updates. I hope that you're as excited for this trial as I am. I'm not saying I'm willing to take days off work to watch this trial, but the temptation is there. Thank you all for watching, and yeah, I'm so excited for this, and I will leave, as always, all of my research links and things below so you can look at stuff for yourself, and I will see you later. Bye, lovely humans. Still don't know how to stop a button.